Kronenberger Rosenfeld. Internet law is our domain.
Here's the California statute, and I do want to dwell on this just a bit. As you can see, we have Section A, 1, 2, and 3. Section A1 deals with using a third party's domain name without the permission of that third party, and people refer to this as an A1 violation. And Section 2 deals with falsified header information. That's from email, from name, IP address, etc. And people refer to that as an A2 violation. And then lastly, we have A3, which deals with misleading subject lines, and people refer to that as an A3 violation. That's sort of the parlance here in the industry. So that's the California statute, which we'll be discussing later. Now I'd like to discuss best practices for advertisers, networks, and senders. First, domain names. As we discussed, this is maybe a stronger argument under A1 that for plaintiffs that they can find a sender sending email with a domain where they don't have permission for it. It may be a better argument than any argument they could come up with under A2 and A3. So the compliance advice is confirm that your senders have permission by implementing a compliance program or working with your network on a compliance program. From names, it's based on the case law. It's better if you're using your brands or your fictitious business names. They don't have to be registered fictitious business names, but it may be better if they are. And you could require your network to require senders to use your brand or your DBAs as the friendly from. Subject lines for your campaigns, you want to take a look at the subject line and the email, match the content up to make sure there are no material contingencies that are not listed in the body of the email. Whose records, as we discussed, it may not be as important than it used to be. And there may be other reasons to keep it open or not, which may be more business operation issues dealing with Spam House. And if you'd ever like to discuss that, I'd be happy to. But just from a legal perspective regarding spam liability, it may not matter that much, but if it doesn't matter to you, it may be best to strip out the privacy and have it open. And last, regarding corporate structures, if you've got a corporation, follow the formalities. However, I do want to comment that because the settlements and the judgments have been well under the cost of litigation, you do not have significant seven-figure liability, which would be a big reason to put a good amount of money into establishing some elaborate corporate structure to protect assets. Because my experience has been with clients who have done that, they've often just litigated the cases and either won or paid some sort of settlement, and it wasn't significant enough to let it go. This is an important point. I'd be happy to discuss this with anybody offline.